Good afternoon and welcome. We'll just wait for everyone to log into the Zoom webinar. Good afternoon, everyone, and welcome. You're joining the session on certification, due diligence, and fees, which includes record keeping. We'll just give everyone a moment or two to arrive. Tēnā koutou katoa, ngā mihi nui kia koutou katoa, no mai, haere mai. It's my pleasure to welcome you to the last of our in-depth seminars for the consumer advisory sector on the changes to our credit laws. As most of you know, because you've attended a couple of these now potentially, we've used your questions to structure today's discussion, and we hope it's useful for you. So today's seminar focuses on certification, due diligence, and fees. And our expert, Alex Smell, will be addressing some of your key questions. And you can put questions in the chat and we'll answer them as we go. But before we get started, I'll open with karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga, kia mā kena kena ki uta, kia mā taratara ki tai. E hiaki ana te atakura, he tio, he hoka, he hauhunga, ti hei mauri ora. Now, before inviting Alex to speak with you all, I'll quickly go over some housekeeping. If you have a technical issue, please raise your virtual hand. It's under reactions on the bottom of your screen, and we'll see if we can assist in the chat function. You can also use the chat function to ask any questions that arise for you during our discussion today. We received many questions from all of you after the high-level overview seminar a couple of weeks ago. And we've used these to go through the session today. Now, Penny Fitzpatrick is handling our Zoom, and I'll introduce her now. Welcome, Penny, and thanks once again for helping us out.
Kia ora, Sonia. Kia ora tātou. As Sonia said, I'll be helping out with the chat today. If you have an issue, please pop it in the chat and I'll try to help you, or any questions you can send through. There'll also be a survey pop up at the end, which you can add your questions there for further follow-up. Kia ora.
Thanks, Penny. Thanks so much. So now let's welcome today's expert, Alex Smale, and he's a legal counsel in the credit branch at the Commerce Commission. Kia ora, Alex. Thanks for joining us.
Kia ora, Sonia.
Now, today we wanted to address some of our consumer advisors' queries from the survey that they filled out after the high-level webinar. And we also want to have the ability for people to pop some questions in the chat function, as I was saying earlier. But before we start doing that, do you want to give us a bit of an overview about the new certification requirements?
Certainly, and kia ora koutou katoa. So, Sonia, as you'll be aware, from the 1st of October, lenders and mobile traders will need to begin being certified by the Commerce Commission. This is in order to raise the standard of lenders and mobile traders operating in the credit industry and to provide better protection for consumers.
Hey, so Alex, does this apply just to individuals or is it to organisations as a whole?
It applies to lenders, whether they are large organisations or smaller entities like sole traders. So to gain certification, all senior managers and directors of the lender will need to be assessed as a fit and proper person to do their job. In a small sole trader, there may only be one individual who needs to be assessed, while in a large company, it may be that all members of the board, as well as all of the managers that report directly to the chief executive.
That's really interesting. I know we've talked about this a lot. And one of the things that I think everyone's really interested in is, you know, what defines fit and proper? We know it's in the legislation. What does it actually mean?
So there aren't legally prescribed considerations, and instead the Commission has developed an assessment criteria. So the criteria fall into two categories, which are on one side, character, reputation, and financial integrity, and on the other side, competency and capability. So in assessing character, reputation, and financial integrity, we look at the suitability of an individual to perform their role as a director or senior manager. That means we consider things like past behaviour, convictions, bankruptcies, and previous enforcement action the Commission took against a lender that the individual was involved with at the time. In assessing capability, we look at an individual's skills and competency to perform their role, which takes account of their employment history and their qualifications. The information provided for the assessment is reviewed from a holistic point of view, and no one single criteria will determine the outcome of the application. I should just say here, if you're interested in looking at the application form that lenders must complete when they're applying for certification, there is a sample copy of the application form on the Commission's website.
I see Penny's just popped that in the chat function. And there's actually a couple of other links in the chat function too. If you want to watch it later, there's a link to the high-level seminar about these subjects, which gives you a good overview of the changes to the law. And there's also a link to some really detailed handouts that we've created. And there's 5 of these, kind of one for each main part of the legislation that's changing. Hey, but back to certification. How long does certification last for?
Certification lasts for 5 years, and so after 5 years, an individual lender has to reapply for certification.
And how long do you think it's going to take for all lenders to be certified? It's quite a big job.
It certainly is, yes. So certification started becoming compulsory on 1 October of this year. So the regime's in effect now. But an important thing to keep in mind over the next year is that certification applications tie in with the lender's annual renewal of their financial service provider, or FSP, registration. So this means that not all lenders will need to be certified right away. Lenders who are already registered on the FSPR and whose annual FSPR renewal falls after 1 October will have more time to apply for certification. This also helps us by spreading out the applications over the next year. So certification applications will be processed over the course of the next 12 months. And by this time next year, we would expect that all lenders that meet the criteria will be certified.
Oh, that makes sense. So then once a lender's certified, is that it? Or is there anything else that they need to do?
So directors and senior managers of lenders have an obligation, once the lender is certified, to remain fit and proper people to perform their roles. Any material changes that could affect the lender's certification will need to be communicated to the Commission within 10 working days of that change. So those are things like changes to the identities of the directors and senior managers, i.e. who is filling those roles, as well as convictions and bankruptcies among existing directors and senior managers. Now, there are penalties if a lender breaches the certification requirements, and the court may order payment of these penalties so there's four things. If a lender provides consumer credit without being certified, or if it has been cancelled or suspended. If a lender represents that they are certified when they're not. If a lender does not notify the Commission of changes in their circumstances as they are required to within 10 working days of knowing about the change. Or if a lender provides false or misleading information on their application for certification. So I'll reiterate here that all of the lenders, directors and senior managers need to be assessed as fit and proper people for a lender to be certified. So if there's a change to the people occupying those roles, the lender will need to let us know, or else they may be in breach of the Act and their certification could be cancelled or suspended.
Thanks, Alex. So let's think of an example. If a lender had, say, 2 directors and 4 senior managers, and they make an application, and 2 of those senior managers are assessed as not being fit and proper to perform their role, what happens then?
Yeah, it's a good question, and we've considered it in our guidance. So our guidance explains reasonably clearly what happens in that case. Basically, the lender cannot be certified until every one of those directors and senior managers is approved. So the unfit directors or senior managers will need to be removed or replaced before that lender can be certified. And without the certification, the lender cannot offer or continue to offer consumer credit or mobile trading services. So it's important to get right.
Hey, I'm sure there'll be people watching who'll be wondering what happens if an unfit director or an unfit senior manager demotes themselves and carries on in the business.
Sure. So we've recognised that as a possibility, and one way that directors and senior managers and unscrupulous lenders may try and get around the requirements. And we've developed some guidance on that. So we stress here that the individual who did not meet the fit and proper person threshold must not assume a role equivalent to that of a director or senior manager in the lender or mobile trader. So we say that the role of director or senior manager is not about the individual's title, but about the role and function the person performs in the business, including the level of influence that they have. I'll say here as well, there are obvious risks if this guidance is ignored, and an individual who has not been identified as a director or senior manager, but performs an equivalent role, could expose the lender to substantial penalties of up to 600,000, or for an individual, 200,000.
Yeah. Hey, so Alex, the consumer advisors will be really interested to know how they can find out whether a lender is certified. Do you want to talk us through how they go about doing that?
Yeah, I can. So a lender's certification is linked to their financial service provider's registration, and anyone can look up a lender on the FSPR website and find out whether they're recorded as being certified or if they're exempt from certification. So I'll just note here that there are some instances where a lender is exempt from certification, such as where they're already licensed with the Reserve Bank or with the FMA. I understand Penny's got a screenshot she'll be able to share to show where you can see on the FSPR website if a lender is certified. So as you can see, it's just under the Financial Services tab there. So if a lender is not registered on the FSPR, then contracts they have entered into with borrowers may not be enforceable. And if they are registered, but they're not certified to provide consumer credit or be a mobile trader, then they could be subject to significant penalties.
And so what happens if someone disagrees? Can anyone challenge an application? And will the lender know when someone is challenging an application?
So the CCCF does not set out a formal complaints and objections procedure like some other licensing regimes do. As always, you can make a complaint about an entity or about an individual director or senior manager to the Commission. And if the complaint leads to enforcement action against the entity or individual, the information may well be considered relevant to our fit and proper assessment and may affect the lender certification status. Now, I understand that Lizanne has previously spoken to the audience about making complaints to us.
Yeah, great. And if anyone's got any questions, feel free to pop them in the chat, and we'll do our best as we go through the session to make sure that we can answer them. If you think of something afterwards, there is a survey at the end where you can put your questions in. And if we aren't able to answer your questions live, then we will be going through all of the questions that are loaded and to see if we can answer them. So we'll make sure that we come back to people on that. Alex, can anyone see who has applied for certification?
Yes, so you can check the lender name on the FSPR under the Maintain Financial Services tab. If a lender has applied for certification, it should show up as waiting for authorization under their certification status. You can also check when they need to apply by looking at their annual confirmation filing month on the General Details tab of that website. So we've advised to lenders that they should be applying for certification at least 2 months before that date of renewal, and because they'll need to be certified by the end of that month.
Great. Hey, Alex, there's a question that's popped up in the chat that I think is quite relevant now, where someone asks, does the certification need to be on display? And I know we were thinking, and one of the questions that came through in the survey was, will mobile traders have to have a visible sticker or a sign to prove that they're certified?
No, so there's no requirement of that. But as I mentioned earlier, you can look them up on the FSPR website to check, and they should be there. So their FSPR number and their trading name are part of the information that lenders are required to disclose as part of the initial disclosure that they provide. So you might recall initial disclosure is the key information that a lender must disclose to a borrower before a loan is entered into. So you can look for the FSPR number and just copy this into the search function on the FSPR website, and the lender's details should pop up there, including whether they're certified. It's often easier to use the number rather than trying to search the name of a lender, as sometimes a lender might have a different trading name to their company name, to the registered name, etc.
That makes sense. Hey, so can a lender lose their certification once they've been certified?
They can, yes. So the Commission can suspend or cancel a lender certification if, among other things, we receive information about a material breach of a certification condition, because we can impose conditions of certification, or if we receive information that leads us to believe that any one of the directors or senior managers is no longer a fit and proper person to perform their role. If the Commission intends to suspend or cancel a lender certification, then there is a process in place that we will follow.
Alex, I wonder if it would be good to give an example of when someone's certification might be suspended or cancelled. Helps people understand it.
Yeah, I can do that. So this might occur where additional information has come to light that is relevant to their certification, but was not provided earlier in the process of applying, or it might happen where something's happened after certification was granted. For example, if a person is convicted of a criminal offence, if they become bankrupt, or if they become subject to a management banning order, that will be relevant and affect their certification status potentially. An event like that won't automatically lead to suspension or cancellation, but it could result in it if it's significant enough on its own or in combination with other issues, and if it's not remedied to our satisfaction. It also could occur where there are, say, a number of individuals in an entity with very little experience, and only one with significant experience. If the individual, whether they be a director or a senior manager with significant experience, leaves the business, and we weren't satisfied that the remaining individuals had significant experience to take care of compliance, then we might cancel or suspend the entity's certification.
Hey, so Alex, I know our listeners will be thinking, if that happens, what happens to the client's loan if the lender fails certification? What happens to the consumers or the borrowers?
Yeah, that's a good question, Sonia. It's one we've had to do a bit of thinking about. So we're currently in the process of developing an enforcement approach that would apply when a lender with an existing loan book fails certification. So what we anticipate is likely to happen under that process we're developing is that the lender will be required to immediately stop entering into new consumer credit contracts or extending existing contracts. And then the Commission would likely give the lender a certain amount of time to allow them to make arrangements to transfer or to write off or otherwise deal with its existing contracts, as well as winding down its business activities like advertising. The lender would also be given the opportunity, we think, to make limited customer-focused or customer-requested variations.
Oh, that makes sense. Hey, yeah, so Alex, that's great. Thank you for providing that kind of piece of information on certification. I know people will be really interested in it, and I see there's a few people that have joined in the chat function. There's a couple of links. There's one to the previous session which gives a high-level overview of all of the changes. There's one which gives links to where the detailed handouts are, and there's some specific ones on certification that you might be interested in if you don't have them already. Hey, now, Alex, many of the people here today will know that we created a resource or refreshed a resource called Red Flags. So, you know, many people will be familiar with that. But Lizanne, our senior advisor in the credit engagement team, has refreshed it significantly with the support of others, investigators and lawyers and all sorts. If people don't have a copy, they can email us at credit.advocacy@comcom.govt.nz, and that you can get an electronic copy, or if you'd like a hard copy, because it's bound and it's got the handy ring on the side, so it's good to keep in your office, you can email us and order some for your office and your staff. So now what we thought we'd do is we'd actually talk about some of the red flags around certification. And I'd like to introduce Lizanne. Lizanne Gibbs, our Senior Advisor, Credit Engagement, and many of you will be familiar with Lizanne, to talk about some of the red flags around certification. Kia ora, Lizanne.
Hey, kia ora, Sonia. Thank you so much. Alex, I think it'd be really helpful for our audience to have some guidance when they come across situations that just don't quite seem right. For our first one, what do advisors or financial mentors do when they come across a lender they haven't heard of before and nothing comes up on the FSPR for that name?
Yeah, so that could appear a bit alarming at first, for sure. So the first thing to do would be to ask your client for a copy of the contract or the contact details of the lender, failing that. So we mentioned this before, but the lender's FSP number must have been provided in the disclosure statement that was given with the contract. From there, you can search for the number and it should be there and it should be current. As you may have guessed, some lenders trade under other names, but these are linked to the parent company and should show up on the FSPR. If nothing at all comes up when you look for that number or that trading name, when you search, that's a red flag and you should let us know. So just send a quick FYI, I believe, Lizanne, you might be able to confirm this. It's notify@comcom.govt.nz.
Yeah, thanks.
So if you do find them on the FSPR, you can also check if they're certified, if the lender's certified, and you can look for this on the Financial Services tab. So if it shows that they are a creditor under a consumer credit contract and additional information shows that they are providing consumer credit, then they'll be expected to be certified. I'll just pause here though, just remember that during this first year of certification, not all lenders will show up as being certified, as the requirement to become certified ties in with the date of their annual FSPR confirmation renewal.
Yeah, thank you, Alex. That was really useful. We have another one. What should an advisor do if their client tells them that they owe money to someone in their community? And upon further questioning, it seems quite a few people owe money to this particular someone.
Yeah, that's definitely a red flag. So there are a few things to think about here. So first, ask your client whether this person is asking for interest on the amount owing, or is charging any fees for the credit, or has taken something to secure payment that they intend to take away or to sell if they don't get paid back. So if that's the case and they are making a regular practice of lending money, then it's possible this person is providing consumer credit contracts and should be both registered on the FSPR and certified. This is a tricky situation, we understand, because obviously it's quite informal. But if you can, try and find out the name of the person, or ask your client if they provided anything in writing, if the lender, that is, provided anything in writing about the agreement. So borrowing money from unregistered lenders is highly risky, as the lender may not treat the borrower how they are meant to under the CCCFA. The contract may well be unenforceable, but your client may not feel that they have the option of stopping payments. The thing to do here is try your best to get the details of the lender and the lending arrangement and to notify us about it.
Thanks. Yeah, that is a tricky one. I've got one last one for you. Let's say we are well into 2022 and a financial mentor finds themselves dealing with multiple cases of what they consider to be irresponsible lending from a certified lender. Is that a red flag?
So it's not a red flag for certification per se, but it will be, of course, will be of course a red flag for responsible lending, and it may well be one for due diligence duties, which we're going to talk about soon.
Great, thanks, Alex. I'll just pass you over to Sonia now, and I'll be back with you again for some more later on.
We'll see you soon, Lizanne.
Thank you.
Right, so Alex, a perfect segue to talk about due diligence duties.
Yeah, thanks, Sonia. So my colleague Wendy covered aspects of this new requirement at the sessions a few weeks ago, and so I'll just recap here what was discussed. So the due diligence duty focuses on the new personal obligations of the seniors and managers of senior managers and directors of lenders and mobile traders. So its purpose is to improve compliance with the Credit Contracts and Consumer Finance Act by incentivizing directors and senior managers to ensure that adequate compliance systems are in place. In terms of who is a director or senior manager, we have provided a bit of guidance around this so that lenders can ascertain who within their business needs to comply with this new obligation. So the law change creates a duty to exercise the care, diligence, and skill that a reasonable director or senior manager, as the case may be, would exercise to ensure that the business complies with its duties and obligations under the CCCF Act. This means that compliance with the duty is assessed objectively. The care, diligence, and skill required from each individual subject to the duty will depend on a number of things, including the size of the business, the nature of the credit the lender provides, the nature of the individual's responsibilities, and the level of influence that person has in the parts of the business that are governed by the law.
Hey, so Alex, you know, the other week when we held the lender seminars, which had a really large number of lenders attending, we went into a bit of detail around what is actually required of directors and senior managers in order to comply with the new due diligence requirement. And what we thought would be useful is to cover this off now so that our consumer advisors and people working in that sector can understand what lenders should be doing to ensure that they're compliant. So I wonder if you could start by telling us, what does the duty actually require?
Yeah, sure. So due diligence requires lenders to take reasonable steps to ensure that the ways in which the lender undertakes its lending tasks, in other words, its policies, procedures, and practices, are designed to ensure compliance with the CCCF Act and regulations. The duty also requires adequate supervision to ensure that the lender's procedures are properly implemented and maintained to ensure compliance. So this means, but it's not limited to, taking reasonable steps to ensure that the lender establishes and maintains procedures, which may or may not be automated, that are designed to result in compliance with the CCCF Act and regulations, that it requires its staff, whether those staff are employees or agents, to follow those procedures, that it undertakes reasonable checks on whether the procedures do what they are designed to do, for example, by sampling or testing, and are being used correctly, whether or not those systems are manual or automated. It requires that the lender employs reasonable methods to identify any deficiencies with its systems, and that it promptly remedies any deficiencies that it finds.
Hey, so Alex, when you talk about establishing systems and procedures, what does that mean for a director or for a senior manager?
Yeah, so performing the duty requires directors and senior managers to take reasonable steps to ensure that the lender has a procedure or series of procedures in place for its lending tasks that are designed to ensure compliance. So they can be automated, or they can rely on employees and agents to follow them. But in either case, directors and senior managers are expected to ensure that each system or procedure is designed to meet the lender's obligations, and that might be through quality assurance, and making sure that the procedures are appropriately tested. They are expected to make sure that there is a manager or managers responsible for the development and implementation of the system, and who will report back to the directors and senior managers on that implementation and performance. They're expected to ensure that there is sufficient resource made available to develop and implement the systems and procedures, and they're expected to understand the compliance risks associated with those systems and procedures.
And you said all staff need to follow these systems and procedures.
Yeah, that's right. So directors and senior managers will need to take reasonable steps to ensure that the lender has procedures in place for clearly and appropriately communicating the systems and procedures within the organisation. So this may involve ensuring staff and agents are regularly trained in how to use the systems and procedures, having those procedures accessible in written form where that's appropriate, and by encouraging and incentivizing staff to follow those systems and procedures. For example, in job descriptions and through the use of key performance indicators, KPIs, linked to the use of the procedures. So directors and senior managers should be ensuring that the lender requires staff to keep records of the inquiries they make and how they assess affordability and suitability is one example. And directors and senior managers should also ensure that sufficient record keeping procedures are in place where the system is automated. We also encourage directors and senior managers to take reasonable steps to ensure that any sales incentives that are provided by the lender to its staff and agents are structured in such a way so as to ensure that staff are encouraged rather than discouraged from using the procedures.
Yeah, I know we had really good discussions about that with our lenders, both in the high level seminars and then also in the detailed ones that we did. And I know that we talked a lot about the fact that once the systems are set up and staff know how to use them, it's not job done, is it?
No, Sonia, it's certainly not a case of set and forget for directors and senior managers. They should be undertaking regular checks of the procedures and that, well, they should at least be ensuring that the lender is undertaking regular checks of the procedures and that the results of those checks, including any remedial steps that are required from those checks, are being reported to and considered by those same directors and senior managers. So directors and senior managers should also ensure that the lender is having its loan application records regularly audited, for example, to ensure that staff are properly following the lender's procedures. So that's in respect of affordability and suitability is one example. Directors and senior managers should be requiring reports to be provided to them on the results of any audits that are being undertaken. And if the results are not satisfactory, meeting the due diligence duty may also mean requiring the lender to implement changes to the systems or further staff training. Because due diligence is an ongoing obligation, directors and senior managers should be taking reasonable steps to ensure the lender is identifying deficiencies in its compliance systems as well. Now, this might be achieved through setting policy and compliance targets at a high level and ensuring the lender has a methodical way of monitoring the implementation and use of the systems. Directors and senior managers should ensure that the lender regularly reviews complaints, defaults, and hardship data to help to ascertain whether the procedure has been followed and whether it is sufficient to ensure compliance with the lender responsibility principles and the regulations.
I know that'll be of interest to the people listening today. How then should directors and senior managers be responding to complaints?
Yeah, so our advice to directors and senior managers and to lenders more generally is that complaints should be taken seriously. So our guidance says that they are one of the ways that system deficiencies can be identified. We therefore recommend that lenders regularly review complaints data at the very least in order to identify potential compliance issues. So the duty also requires directors and senior managers to take prompt action where the lender has identified failures with its systems and procedures. The steps that we suggest taking, including requiring management to address and remediate the issue, ensuring that the lender stops using the deficient system in the meantime, or if that's not possible, identifying impacted borrowers and adopting procedures that will mitigate any harm, and ensuring that the lender has a procedure in place to remediate the borrowers affected by the problem today. For example, by making corrective disclosure if it's a disclosure issue, refunding overpayments if for example, it's a cost of borrowing mistake, or by providing compensation where the Act provides for it.
That's really good, Alex. Thank you. Hey, now I'd like to ask Lizanne to join us again because she's got some red flags that advisors might be interested to hear about. Hi, Lizanne. Thanks.
Great. Thank you, Sonia. I'm sure everyone will be glad to hear that complaints should be taken seriously. Alex, I think I'll start off with that scenario we mentioned earlier. If a financial mentor finds themselves dealing with multiple cases of what they consider to be irresponsible lending from a certified lender, what should the mentor do in light of these due diligence duties?
Yeah, so for a financial mentor, you should complain to the lender as soon as possible and explain why you think it's a problem related to their systems. So as I've said, complaints are one method that we recommend directors and senior managers use to detect system deficiencies, and letting them know how many times this has happened, and providing a few high-level details of each case that you're referring to would go a long way to showing what the systemic issue could be. And if complaints are not being taken seriously, this may mean that a director or senior manager is not taking reasonable steps to ensure the lender is remedying issues with its systems and procedures. And if there is a systems issue, the lender should be remedying the cause of the problem in a timely manner. You can talk to the lender about any harm the borrowers have suffered as a result of the irresponsible lending that you allege has happened, and what remedies might be appropriate as a result. We expect directors and senior managers to take the lender's systems and processes really seriously. As mentioned earlier, directors and senior managers are personally liable if they breach their due diligence duties, and they can be liable for penalties of up to $200,000 and may be made to contribute to statutory damages. And of course, just on that, Lizanne, with any significant responsible lending issue, the important thing is let us know. Again, it can just be a notification to the email address that we popped into the chat function earlier.
Right, thank you. Thanks for that, Alex. It's really useful. I've just got one other one. What should advisors or financial mentors do when they or their clients experience communication issues with lenders or experience uncooperative staff? Is that a red flag for due diligence duties?
Possibly. So directors and senior managers have a duty to ensure that the lenders' systems are compliant with the CCCFA and regulations. And the Responsible Lending Code has some guidance for lenders about this. Many of you will be quite familiar with the code by now, but we'll pop a link to it in the chat function. Regarding staff, the duty says that directors and senior managers should take steps to be satisfied that staff and agents acting on the lender's behalf understand what they need to do to comply with the relevant policies, processes, and practices, and with the lender responsibility principles before those staff and agents come into contact with borrowers. So the principles include treating borrowers in an ethical and reasonable manner. If the issues relate to the lender not supplying requested documentation when they have a statutory obligation to do so within a certain time frame, and that time frame has been exceeded, and if that's happening on a regular basis, well, that could be evidence that the directors and senior managers are not meeting their duty. The code also has some guidance for lenders when working with borrowers' representatives, and I believe that's on page 12.
Right. Well, thank you, Alex. Well, that's me for now, so I'll pass you back on to Sonia. Thank you.
Thanks, Lizanne, and thank you for all the work that you do. We really appreciate you. And just a quick reminder, if you want your very own copy of Red Flags, you can email us. The email address is in the chat, and we can send you, there's an electronic copy on the website that you can access, or we can send you a hard copy for your office and your colleagues. So Alex, now we're going to move on to the new obligation that requires lenders to keep records of how they've calculated their fees and any reviews they conduct. Do you want to talk to us a little bit about that?
Yeah, sure. Thanks, Sonia. So that's right. Fees have always needed to be reasonable. And the CCCFA spells this out for the different types of fees. But from 1 December this year, Section 41A comes into force. And this is an important one because it means that lenders must also keep records of how they have calculated their fees and of any reviews that they conduct.
So then what exactly should lenders be recording?
Well, it's quite technical actually, but we would expect that lenders' records would include any costs that they have identified as being closely related to the activities that give rise to the respective fees they charge, and that they explain those costs connection to the fee. For example, with default fees, a lender would be expected to identify and quantify any assessment of loss that could be incurred by the lender as a result of the borrower's default that the lender wishes to recover through that fee.
Yeah, we had lots of questions around this when we talked to lenders about it. It was really good to get that clarity out there. Do you want to talk to us about when a lender should be reviewing a fee? How does that work?
Yeah, so fees need to be reviewed where lenders become aware or ought to become aware of a change that is likely to affect the reasonableness of the fee. So for instance, and this is probably the best example, is if there's been a change in a lender's business costs, an identifiable one, then a lender must, and that's resulted in a lowering of the cost, then the lender must reduce the fee if their review demonstrates that the fee is likely to be unreasonable.
And then are those records, are they able to be accessed?
Yes, they are. So both the Commerce Commission and the dispute resolution schemes can require lenders to provide copies of their fee setting records. So those are specific rights that the Commission and the dispute resolution schemes have. Lenders must make the records available when they receive these types of requests from us or from the DRSs, and will have 20 working days to provide records to the requester. Lenders must also keep records for at least 7 years. So that starts from the date when the fee was set or reviewed.
That's great, thank you. Hey, we got a really specific question after the high level seminar a couple of weeks ago from one of our financial mentors or consumer advisors. And they asked, can a lender charge an establishment fee plus a transaction fee on the same contract?
Yeah, so it's a tricky one without a little bit more information, but basically it depends on what the establishment fee is for and what the transaction fee is for, and what costs that they're said to be recovering. Essentially, the key point here is that there cannot be double recovery with fees. So lenders must be recovering specific and distinct costs with each fee that they charged, and those costs cannot overlap in that sense with another fee. If they do, if the fees are essentially recovering the same costs and they're being recovered twice, those fees could be deemed as unreasonable.
Excellent. So then when we think about the increased compliance costs, we got a really good question about this, which says, are the increased compliance costs for lenders likely to be passed on to borrowers in the form of increased fees?
Yeah, that is a possibility. But again, the fees will still need to be reasonable. And if the fees that lenders are charging have gone up, then the lenders will still need to be showing the relevant costs that they're relying on for increasing those fees in their record keeping.
Yeah, great. Okay, so then if we're thinking about how the fees should be calculated, I know we had lots of questions from lenders about this. Do you want to talk to us about if there's any kind of calculation that lenders should be using?
There is guidance out there. There's guidance in both the Responsible Lending Code, which we've previously talked about, and in the Commission's fees guidelines, which are available on our website. And these both should give enough to develop an approach.
Yeah, great. Now, again, we had quite a specific question come through, which talks about car dealers and finance companies and those relationships between brokers and those parties. And it says, when there is a relationship between a broker, a car dealer, and a finance company, there are often extra fees charged. Are there any changes here with the amendments to the CCCFA?
So there are no changes here as a result of the amendments on this point, but there is some guidance on this point in our credit fee guidelines, which I suppose will be pertinent to refer to here. Essentially, the key point remains, as it was before the amendments, and remains after the amendments, that third-party fees, like those charged by brokers or dealers, must be passed on at cost So the lender cannot add anything to that.
Hey, Alex, there's a good question here. Can we challenge the fees that were charged under old contracts, say contracts that were entered into 3 years ago?
So we can look at those contracts for compliance with the existing fee provisions, which I've talked about. So the requirements that the fees be reasonable, but the obligation to keep records of how the lender sets its fees won't apply until the new provision comes into force on December 1.
Okay, that's great. Thank you. Hey, there's a question here that I think might be interesting. It talks about collection agencies. So will collection agencies also have to disclose their fees?
Yeah, so some of the audience may have attended the disclosure session with my colleague Crystal on Tuesday, where she talked about the requirements that apply for disclosure relating to debt collection and before debt collection. So the short answer here is yes. So from 1 December, there are new requirements in place regarding what needs to be disclosed before debt collection occurs, and that includes any default fees that are being charged.
Excellent. That's fantastic, Alex. Hey, so we've been watching the chat and there's been a couple of questions come through, but we think that actually we've covered most of the ones that we can today. But Alex, thank you so much for your expertise, for your knowledge, your experience and your time. We're really grateful. So Alex, is there anything else you'd like to add?
No, nothing from me. I'd just like to say thank you to everyone for joining in and participating. It's really good to have some really active and passionate financial mentors out there, and I hope this has been helpful. So thank you to everyone.
Wonderful. Thank you so much. And thanks to all of you once again for watching our webinar. We really appreciate that you've taken the time to listen to our experts. So again, like last time, we're running a survey where you can let us know what we've missed or what areas you want more details around, any questions that you want answered, that sort of thing. So when the session closes, when you close the window, you'll be redirected to an anonymous survey. Pop your questions in here, and also feel free to let us know what you thought of the seminar. It helps us to improve. And if the survey is blocked by your provider or the computer that you're working on, you can always email us. We'd love to hear from you. And our address is credit.advocacy@comcom.govt.nz. So we have recorded the session, as we have with all of the sessions, and we'll make those available to you soon. So kia ora koutou for your great listening skills. I'll close as we started with karakia. Unuhia, unuhia, unuhia ki te uru tapanui, kia wātia, kia mama te nāko, te tiana te wairua e te ara tangata, koe ara e rongo, whakaere ake ke runga, kia tēnei, tēnei huie, tai kie. Haere rā.